This question comes up a lot when people start thinking about estate planning. What happens to your property when you die without a will? Each state has their own set of statutes to deal with this type of situation because unfortunately it happens a lot. It's called dying intestate, which just means dying without a will. So in California, who will get your property? Well, it depends on your marital status at the time of your death as well as who survives you. If you're married, your spouse will get 100% of your half share of community property. California's community property state, and that means that all of the property you accumulate while you're married belongs to the marital estate. So you and your spouse each have a 50% interest. Without getting into the details of community property, you could also have separate property, even if you're married. So in addition to 100% of your community property, your spouse will also get either 100%, 50%, or 33 1/3% of your separate property, depending on whether you have no child, one child, or two or more children. The rest would be split among your children or a qualifying relative. Now, if you're interested in looking at the specifics of what a qualifying relative is, you can go directly to California Probate Code, Section 6401. Now, if you're not married, it's a little easier to determine how your stuff will be distributed because there's no division of community property and separate property. It's all just your property. So if you're not married but you have a child, that child will receive 100% of your property. If you have more than one child, then it will be split equally. If you're not married and you have no children, then your parents would receive 100% of your property. And if you're not married, no children, no surviving parents, then your property would go to your brothers and sisters if you have any. And if you don't have any of the relatives above, then next in line would be your grandparents, aunts, uncles, and on down the line. One thing I haven't mentioned is that the laws also take into consideration surviving children of your relatives. For example, if you had 3 children and one died before you but left 3 grandchildren, those grandchildren would take the deceased child's share. The intestate laws can be confusing and everything depends on who survives you, but there's a simple way to avoid all of the confusion associated with the intestate laws. Prepare an estate plan in advance so you can choose exactly how to distribute your estate. An estate plan can do more than just help avoid confusion when you die. It can save your family a lot of time and money. If you're interested in more information on estate planning, you can visit the Doyle Quain website at familylawgroup.com and check out our free California estate planning guide. That's it for this video. Thanks for watching.